Hey everyone, Trip Watson, entrepreneur attorney with the Watson firm, giving you an update on Samsung versus Apple. We've had a Supreme Court ruling that could have an adverse effect on inventors. In case you don't already know, there was a major lawsuit between Samsung and Apple that resulted in a $399 million patent infringement lawsuit judgment against Samsung. Now, Samsung's appealed this up with the Supreme Court, and the Supreme Court has ruled in Samsung's favor, knocking down the $399 million judgment to the lower court to decide on future proceedings. Basically, the issue in the case involved Samsung being sued by Apple because Samsung had a design patent on basically a black rectangular phone. However, Samsung's argument was that Apple shouldn't be entitled to 100% of the profits simply because they designed something that was very similar and had a patent on it. There was a lot of other components involved in the product, such as its cell phone service, its app design, and a number of other functional things that made the phone different than Apple's design. Now, ultimately, the Supreme Court, not surprisingly, agreed. Just because you design some small part of a multi-component in product doesn't mean that you're entitled to 100% of the profits. However, the problem is that inventors that have had their patents infringed used to have the inference that they were entitled to 100% of the profits of everything that was sold off of their design. Now there's going to be an additional element that inventors are going to have to show that they had a critical component in the end product so that they're entitled to most, if not all, of those profits. So it's just going to make the already expensive process of prosecuting a patent even more expensive. If you'd like to find out more or figure out ways to protect your ideas or inventions, I hope you'll give us a call. Trip Watson, Watson Firm. Have a good day.